Welcome, everyone. I'm Lee Meriwether, and with me is Todd Orston. Todd and I are partners at the law firm of Meriwether and Tharp, and you're listening to Meriwether and Tharp Radio on the new Talk 106.7. Here you will learn about divorce, family law, tips on how to save your marriage if it's in the middle of a crisis, and from time to time, even tips on how to take your marriage to the next level. If you want to read more about us, you can always check us out online at AtlantaDivorceTeam.com. You know, Todd, one of the things that frustrates me with being a lawyer is I can't help everyone. You know, there's certain limitations. I mean, and for a lot of people that go to law school, they've incurred a lot of financial debt because, you know, law school, there's an extra 3 years on top of a college education, and then there's time you take off often to study for the bar. So there's sometimes people borrow money for that. And gosh, I've seen lawyers out there that they're and doctors too, for that matter, where their student loan payment is more than their mortgage payment. And so that just puts them in a bind.
Yeah, it's you don't need to listen to us to know hiring an attorney can be expensive.
Right.
And sometimes people get put off because they think about, or they go and talk to an attorney, they think about how much it's going to cost to retain an attorney. And it can be a lot of money. We're not talking about tens of dollars. We're not talking even hundreds of dollars. Oftentimes, it could be in the thousands, $2,000, $3,000 or more dollars. And, you know, it's interesting because according to data collected by the American Bar Association, there are, or when there are situations where an attorney doesn't charge enough, because, again, sometimes people have a complaint about that. Right. When attorneys don't ask for enough money, it gets them into trouble because they run out of money. The work that needs to be done can't be done. Sometimes even attorneys find themselves going out trying to get other clients to get more money and retainers paid just so they can do work on older clients.
Right.
They just don't have enough. And then a lot of those attorneys fall into the category of, I want to help everybody, but I can't.
Right. And so it creates a serious tension. And there's lawyers out there that do pro bono work, and then you've got legal aid. So there are options out there, but I mean, most lawyers are going to limit the amount of pro bono cases they take because they still have to pay their bills. And if they have a family, they got to take care of their family. And so there's all those just expenses of life.
Yeah. And legal aid, first of all, it's not even in every county.
Right.
And in the counties where there is a legal aid, getting them to handle your case, first of all, there has to be, you know, a certain there's a financial requirement, a threshold. And if you make too much money, and we're not talking about a lot of money. If you make too much money, then you won't qualify. They won't help you. And even if you do meet that threshold, sometimes they're just too busy. They're handling too many cases. And like us, they want to help everybody, but they can't.
And so what that leaves is a large group of a large number of people in the population that are in court representing themselves. And we've talked on other shows, you can do that, but the problem is when you're in the courtroom, a judge and the clerk of court, they can't give you legal advice. So you could be in court presenting your case, but not know, hey, I need to tell the judge X, Y, and Z in order to receive A, B, C, and D from the court out of my divorce. If you don't ask the right questions, if you don't present the right evidence, the judge has to make a ruling on the evidence presented in the courtroom. And so we see pro se litigants, people that represent themselves, get really a raw deal sometimes. And it's not because the judge is doing them wrong. The judge is following the law. But because of the lack of information or lack of experience in a courtroom, the pro se litigant comes out and gets, I don't know if raw deal is the right word, but doesn't get a good outcome.
Look, what it comes down to, just building on that, judges aren't going to punish a pro se litigant just because they are representing themselves. But a court can only, their decisions they can only do so much with the information that they are given. If a pro se litigant who doesn't really understand what's going to be important on a particular issue to a judge fails to present the right information, the judge doesn't have the necessary information, and therefore it could, and oftentimes does, impact the ultimate decision of the judge. If you, just to, a general example, if you're in court and you're fighting over custody and you go in and don't bring it up or establish or prove that, let's say, your spouse has a drug problem, well, then a drug problem isn't going to come into play in terms of the court deciding what would be a fair, reasonable solution for custody.
Right.
Whereas an attorney might gather the right information, put a whole plan together, a presentation for court, go into court and be able to say, Judge, I have this evidence, this evidence, this evidence. There is an alcohol or a drug related problem that can impact that person's ability to act as a parent, and therefore it needs to be taken into consideration. But without presenting the right things, unfortunately, the judge can only do what the judge can do.
And so it could be even simpler than that. Say somebody came into a marriage with a retirement account, and during the course of the marriage, they really didn't contribute to it, but it grew. If they're in court and they say, Judge, I have an IRA, and she has an IRA, and they think that they're saying we each had our own separate IRAs, the court could just all of a sudden, well, we're going to split those because the person didn't know, Judge, I owned that IRA before we got married. Here's a copy of my statement. So that's an example of financial impact.
Right. So a separate property claim that could have awarded or resulted in an award of a majority of that asset to you because it was your separate property you brought into the marriage. You just waived that entire argument because you didn't present the right information. But going back to what we're talking about and the purpose of the show is that there are many, many people who either by choice or necessity represent themselves in these types of divorce actions, and that's fine. And so what we're going to be talking about today, it goes by, there are different ways to term it or, different ways to refer to it. But basically what we're talking about is just because you don't go out and hire an attorney to represent you doesn't mean that you can't or should not get some level of help from an attorney. Right. And that could be on a consultation basis. It can be, with a la carte legal services that are provided by an attorney and or firm. But what we're going to be talking about today is that. Right. That even if you can't afford to hire an attorney and you can't pay that very sizable retainer, don't feel bad. It's not a self-pity time. All right. It is now figure out how you can get yourself that help.
What's my alternative? And
there are alternatives out there.
And today, that's what we're going to be talking about. We're going to be talking about, one way to say is divorce coaching. That's one way. But we're going to spend the whole hour, we're going to break down what's left, we're going to break down the different, what you should be thinking about, the mechanics of it, at what points in time in the litigation process, the divorce process, should you spend the money on meeting with a lawyer? And we're going to talk about other just derivations of that, just different options, subsets of that too. So that way people, they're like, well, I can't afford to pay the $3,500 or $5,000 retainer, but I've got a few $100s every month that I can meet with a lawyer. So we're going to break that down and go through that.
Yeah, we're going to talk, and just to be very clear, we're going to talk about specific strategies. We're not just going to say, okay, you can't afford an attorney, go and have a consultation. There are times that would be strategically more advantageous to have a consultation with an attorney. We're going to talk about those times.
Yes.
How to communicate with the attorney that you're not paying to, basically that you're not retaining and that is not representing you in the case. We're going to tell you how to communicate to be efficient, to be effective in your communication with that attorney. That's what we're going to go over in this show, so that if you do choose to represent yourself, that's fine. But be prepared. Be ready to at least communicate with an attorney so that you can be prepared for whatever gets thrown at you, whether you can negotiate and settle at mediation, or if you have to have a temporary hearing, an emergency hearing, a final trial, whatever it is, you're going to be ready.
So, just talk about costs for a second. We recently helped someone last year with this process, and so over the course of a year and a half, he actually paid us about $4,000. Now, let's say it may sound like a lot, but I can tell you that if we had been full-time representing him, it would have been between $35,000 and $40,000, just because knowing what was going on in the case. But yet, he actually got an excellent outcome in the case. He got something that, to be frank, I'm not sure I could have done better than what he did. He did very, very well.
And there were some complexities in that case.
Yes, there were complexities,
So,
but he met with me
right.
during certain times. So one of the things I did was I went back and looked at those times, and I said, this would make a great show. We can share this information. So there's others out there that realize, hey, I don't have to go this alone. Even though I can't afford a lawyer to be with me inside that courtroom, I could know what to do before I get to the courtroom. So up next, we're going to go into the best points in time during a divorce process, maybe even a modification, other types of family law cases, where it would be best to meet with a lawyer and the mechanics of what that relationship might look like. Welcome, everyone. I'm Lee Meriwether, and with me is Todd Orston. Todd and I are partners at the law firm of Meriwether and Tharp, and you're listening to Meriwether and Tharp Radio on the new Talk 106.7. If you want to read more about us, you can always read about us online at AtlantaDivorceTeam.com. Well, today we're talking about divorce coaching or consultations, using consultations or a la carte services. I think the American Bar Association calls it unbundled legal services. But we're breaking down the concept of if you can't afford to hire a lawyer full-time in a family law or divorce case, there are other options so that you don't go through this alone. Now, before we go any further, before we get into the specifics, like how to best maximize the use of a lawyer during this process at the best times, we should give some caveats. And I'll start with a state-by-state caveat. So some states, the bar rules have allowed lawyers to do this. Actually, a lot of states, and I don't know, off the top of my head, I don't know if there's any states that actually limit it, but I'll give you an example. So in Georgia, a lawyer can actually draft a pleading for a client that's representing themselves in court, and they do not have to put their name on it. So as far as the court knows and the other side knows, the pro se litigant, the person representing themselves in court, so that's the term of art, pro se litigant, they don't have to disclose that. But in Florida...
And there's a term, ghostwriting.
Ghostwriting, yes.
So,
but in Florida, it's in the bar rules that the lawyer must, so if the lawyer drafts the pleading, they must write on there that this pleading was prepared by and the name of the lawyer. So they may not be in court with them, but they have to disclose that. So every state's a little bit different. So depending on what state you're in, you're going to need to reach out and talk to lawyers. But we'll be focusing more on Georgia, but I did want to give that caveat. If you're listening from somewhere and your case is another state, check with the local lawyers.
And keep in mind, what we're talking about is, this is a show about communication with an attorney.
Right.
It's just what kind of communication are you having? Mm-hmm. Is that attorney representing you, or are you engaging in that kind of a pro se consultation kind of relationship, in which case you're going to be asking these questions, whatever state you're in, of the attorney. Hey, pursuant to bar rules here in this state, are you able to draft things for me if I pay you for that? They might say, I can, but my name has to go onto the document. Or here in Georgia, like you just said, that's fine. Yes, we can help you with some drafting, and then you can file everything on your own.
So the other thing is what to expect in the relationship with the lawyer. So there's some lawyers out there that they're going to just want you to, hey, I'll meet with you. I'll go through your stuff in our meetings, everything, but that's the extent of it. And there's other lawyers like us where we do this, where you can say, hey, can I send you some follow-up emails, or can we have follow-up telephone conversations? But from our perspective, we actually want that money up front. So we're just explaining there's other lawyers that may want this, just a little bit of money set aside so that when you call, we just bill off that small bit of money. Maybe it's $500 or $1,000, depending on the nature of the type of case and how many times you may have to call. And that helps to facilitate the communication and keep the lawyer engaged with you.
Yeah, and let me put it this way. Do not be shy. If you know that you are going to run into some financial constraints, when you pick up the phone and you talk to an attorney, more than likely, a lot of firms, the attorneys are going to be selling themselves in basically for, you're going to retain me, I'm going to be your attorney of record, I'm going to do all the work that needs to be done. That's what they are selling you when they are, on the phone with you and you're talking initially. There's nothing wrong with that. That's what we do. Mm-hmm. But they may not be very good at saying, yeah, but there are options. All right. With us, we do a little bit, I believe, better job, or at least a good job of saying, okay, here are your options. If they don't talk or come up with it, and say, oh, yeah, by the way, there's some options if the retainer is going to be a problem, don't be shy, ask.
Yeah.
Because you might be able to say, hey, retaining is going to be difficult, just being honest with you, but I've heard about consultations or unbundled services. If I need you, and can I just pay as I go? And I know you won't be going to court with me. I know you won't be entering an appearance and you won't be my attorney of record, but can I at least get some help? And they may be able to do that.
And I know I'm maybe jumping ahead a little bit because I had this noted to talk about later, but I think you've opened the door to just mention one more thing. Like, you may not be able to retain a lawyer today, but you've been served with a complaint for divorce. So you don't have a choice. You have to represent yourself. You just don't have the money put together. What you can do is you can follow that divorce coaching concept or divorce consultation process and wait till you get the money later and have the lawyer step in. Cases where the client, they had a budget, and so they had us work with them through the course of the entire case. And then when it came time for a final hearing, they came and retained us just for the final hearing. And we made a limited entry appearance just for that final hearing. And because they didn't feel comfortable representing themselves at that last hearing.
Yeah. And sometimes, a lot of times, we can make that work. Sometimes it's not going to be possible. If you're going to have, if you're going to have a very hotly contested, complex case, it may not be possible. And because too much work needs to be done, for you to really get the help that you need, you're going to have to be doing consultations constantly. It's going to still be a lot of money.
In the example I gave, she was coming in once a month. She actually had a regularly scheduled appointment with us to talk about where she was. So I believe the attorney that went to court for her was aware of the whole process. So that was very helpful. She had a very positive outcome, too.
Yeah. I mean, one of the main messages of the show is going to be you have options.
Right.
And you should always explore those options because it is better for you to at least talk with an attorney to get some tips and better understand strategy and things that you need to do to protect yourself than to not do that and just try and truly do everything on your own.
So let's talk about let's start getting into the specifics of what point should you reach out to a lawyer and have them double check things. So I would say the first thing is the filing of any pleading. And a pleading is a document that you file with the court. So the pleading that starts a divorce is called a complaint. So you would want to have a lawyer review the complaint. They may want to make sure they're going to want to make sure you've got the necessary points that are required to start a divorce in the complaint. They may have you take out some points that are unnecessary.
Yeah, and I'm also going to hit it from a different angle because sometimes you're talking about the drafting.
Right.
There is strategy that goes into the drafting of the complaint or the drafting of an answer in response to the filing of a complaint. So for the plaintiff or petitioner, it would be beneficial and advisable as you are putting the paperwork together, go and have a meeting with the attorney. Understand, because
so it could be just more than just the drafting. It's
it's the strategy behind it. If alcoholism is an issue, does that need to be put into the complaint? If there's adultery, does it need to be put into the complaint? What are your goals? What are you trying to accomplish with the filing? I mean, obviously the basics in a divorce, your goal is to get a divorce. But, do you want this to be amicable? Do you want to try and work things out quickly? And the same thing goes for the respondent or defendant who is responding to the filing of the complaint. You may want to, not just talk about the drafting and the form of your answer, but how should I respond? What are some strategies I should be thinking about to put me in the best position possible, whether your goal is mediation and settlement or, unfortunately, you foresee hearings and trials in your future. You need to understand a good strategy.
And so those two pleadings are relatively simple, complaint and answer, but there may be the other motions that are much more complex that will take a lot more time. Like a good example might be a motion for a guardian ad litem or a motion for a custody evaluation, a motion to compel. Those are just I'm going to throw out some examples. But again, on those motions, there's a strategy. There's, should we file these motions? Should we file what's called a motion for guardian ad litem over a motion for custody evaluation? And if you're at a point where you've got contested custody and you don't know, so my other tip was actually, if you get stuck and don't know the next step, so these kind of tie together, you would come in and talk to a lawyer and say, here's my concerns about the proposal that the spouse has given me for parenting time. And then what do you think would be my next best step? And it may be, well, gosh, you've got these concerns about alcoholism. Maybe we need to have a guardian ad litem investigate or have an alcohol evaluation done, and you'll learn that the court's going to require both parties to participate in that. So that's another point where you want to just have that meeting, and then they'll give you the tips on what to do, and you can just start executing on it.
Yeah. So what it really comes down to is you just need to be very strategic in how you speak to and when you speak to an attorney, because if you are strategic, I mean, the way that we're describing it, if you listen to it one way, you might be like, well, great. I'm going to save money because I'm not retaining, but I have to have a consultation at this point, and then at this point, and then another point, and And next thing you know, you've done 15 different consultations, and you spent just as much as you would have if you had retained. That's not what we're saying. There are options, and if you're strategic, if you go in at the right time and ask the right questions, then you can figure out and limit what you need to do and limit the number of times you need to meet with the attorney to figure that out and do it the right way.
And up next, we're going to go into 4 other situations where you'd want to sit down with your divorce coach. Welcome, everyone. I'm Lee Meriwether, and with me is Todd Orston. Todd and I are partners at the law firm of Meriwether and Tharp, and you're listening to Meriwether and Tharp Radio on the new Talk 106.7. If you want to read more about us, you can always check us out online at AtlantaDivorceTeam.com. Well, today we're talking about divorce coaching, or it's an alternative. If you can't afford to hire a lawyer full-time to represent you in your divorce or similar family law action, there are other options out there. You can use what's called an a la carte services or unbundled legal services, and those options are becoming more and more available across different states as state bar associations realize that, well, people need help in courts and they can't always get the legal services they need. So we're talking about the mechanics of what that might look like, and we've been giving examples of the points in time during your case when you really do want to sit down and talk with a lawyer. All right, so let's keep going. So another thing we see a lot of times is somebody will get a settlement proposal, and like in the beginning of the case, oh great, and they'll look at it and they seems fair to them on the surface. Maybe they feel a little bit guilty about an affair, and they're like, well, I should probably do this because I did something wrong. Don't sign anything till you meet with a lawyer.
Unadvisable, because I can tell you right now that, again, we want nothing more than for you to be able to get through a divorce process quickly and efficiently. But I can't tell you how often people do that, meaning they sign off on an agreement. They don't get it reviewed. They don't make any changes because they don't know what to change. And then they're calling us saying, hey, I entered into this agreement, maybe even entered into the agreement. It was then made a part of a final order. Wow, these terms are really unfair. What can I do to change them? And usually at that point, our answer is, well, pretty much somewhere between nothing and absolutely nothing.
Yeah.
So
there's a lot of pitfalls that people can run into, like being what we call stupidly generous. Another thing is you see people agreeing to things that a court can't order on their own. A good example of that is agreeing to pay for college education, particularly with no limiting factors.
And don't get us wrong. If you want to participate in the payment of college tuition and expenses for one of your children, fantastic. I'm not saying
we're not saying don't do that.
We're not saying don't do it.
Just don't put in the order.
But we have seen problems where there are people whose jobs and incomes have gone. It's been affected by the economy, or it's just in some kind of it's a type of job that you may work here for a year or two, but maybe not, and then you have to go look for another job. I've seen people lock themselves into college tuition and there aren't any limitations. And then they're coming to us because they lost their job. They were hurt. They can't earn. And guess what? They're still on the hook to pay for college.
Yeah, even though they can't pay.
Even though they can't.
So that's the things that a lawyer will go through with you. Another thing on the flip side is that perhaps you are arguing about a point that you really shouldn't. You see something, you don't feel like it's fair, but you know what? That may be the law. The proposal may actually be fair, even though it feels unfair. And so you don't want to waste time and energy, and perhaps you're on the cusp. You go one path, you're going to have a great co-parenting relationship with your spouse, but you go the other path and you're going to be butting heads for the entire time that your kids are minors. So, a lawyer can provide clarity there too. And lastly, I think a good thing to remember is sometimes lawyers will present things with a certain level of confidence, not trying to be mean or pushy, but like, we think this is really a fair offer. And they present that they use that magic word, fair. Oh, it's fair. I need to consider it. And it's the way they do it. It's the presentation, everything. Well, double check with a lawyer because maybe it's not fair.
Or maybe it's really fair for the lawyer's client.
True.
So, you have to make sure that it's fair for you. And what we always say is that, understand that the terms of the agreement that you reach or an order, if you get an order from a court, meaning that you have a trial and the judge issues an order, that's going to carry with you for years to come, potentially. Yeah. If you have children, if you're paying child support, alimony payments, division of property and debt, if you're giving up because you don't know any better on separate property claims, these are things that are going to carry with you and have a major impact
on the rest of your life.
That's right.
So there's two good books out there. I'm just going to throw Never Split the Difference and Getting to Yes. Those are good negotiation books that you might want to pick up on your own and then use that the information you would gain from that in conjunction with your consultations with your lawyer. All right, so another phase where you may want to sit down with a lawyer would be discovery. So what's discovery?
You get on a boat and you look for new lands and right? The Nina, the Pinta, and the Santa Monica? No. All right, so history wasn't, no. Discovery is it's definitely discovering I have a bad sense of humor. Discovery is you are discovering information that you need in order to resolve the issues in your pending case.
Right.
So basically you have a right by law to engage in discovery, and that means you get to ask questions, gather information. In other words, the other party can't say, oh, you want to know how much money is in my account? Too bad. Not going to tell you. And sure. No, you have a right to ask that question. How much money do you make from your employer, from your employment? Not going to tell you. Well, yeah, you are.
Yeah.
Because we are engaging in formal discovery. Here's my request. Please show me what's in your bank account. Please show me what money you're earning from your job. Please show me whatever, as long as it's reasonable and reasonably calculated to basically result in the presentation and discovery of pertinent information, relevant information to the divorce, then you can ask about it.
Right. And so you can meet with a lawyer and talk about the mechanics of how to go about getting the information you need. And perhaps you've received discovery requests from the other side. A lawyer can make sure that, especially if it's a contested custody case, you know what, let's be truthful, but let's phrase it a little bit differently because sometimes words matter. So,
it's always be truthful, but sometimes it's not just what you say, it's how you say it. So I've had people say something to me, and I'm not going to use examples, but where they'll say it to me, and I'll be like, well, hold on one second. The way you just described it to me, I want to put you in jail right now. And I don't even think I have that right. Yeah. So maybe let's reword it. Tell me what you're trying to say. Okay, now I get it.
Yeah, that sounds much better.
Yeah, you didn't commit 3 felonies. And so, okay, let's describe it a different way. So you have to be very careful. And also when it comes to asking for a discovery, just jumping back to that, if you don't ask the right questions, you don't have the information that you need to make good decisions.
Yes.
So it is so important on both sides to get to the point where you are comfortable and you're asking the right questions and giving the right information. You say the wrong thing, going back now to what you say in response to discovery. You say it the wrong way, the judge might look at you. Those words will be used against you in court.
Yeah. So meet with a lawyer. They'll help you ask the right questions. They'll help you answer the questions in a way that sounds good. And again, not saying you're not truthful, but sometimes you just phrase it a way that just sounds better.
Yeah, like if you did commit a burglary, well, I just borrowed the TV.
Plead the fifth.
Yeah, right. Yeah, exactly. Right.
So, all right. So the other thing is mediations. So before you walk into a mediation, let's say mediation has been scheduled, you should meet with a lawyer and talk with the lawyer about, okay, what should I be looking for? Here are some facts. What do you think would be a good outcome for me? What should be included in our final agreement that comes out of mediation? What should I not agree to?
And what are the mechanics of the mediation process? When I get there, I don't want to be surprised by the fact that we are either both in the same room with the mediator sitting right there, or the alternative that they're engaging in what's called separate caucusing, where you are immediately separated from the other party. You're in one room, they're in the other. You spend 10 minutes explaining what your positions are, and then 3 hours later, the mediator comes back, and you're sitting there going, they must really like the other party, and they are playing favorites because I only got 10 minutes and they got 3 hours. You need to understand the mechanics of it, too.
Yeah, because in that situation, we've seen that where we'll come in very prepared. We'll be very concise. Here's our proposal. Here's why we think it's fair. Great. I'm going to go to the other side. Well, the other side's not nearly as prepared.
Or emotion is driving. They have to just get it off their chest. Mm-hmm. And they're, in the third grade, I stole a frog. And, no, it's not relevant to the divorce, but they have to get it out. Yeah, right. Yeah. So.
Just kidding. No, but when you learn that and you're in that mediation, you realize, okay, this is part of the process. I'm not going to mistrust the mediator all of a sudden.
Which can impact settlement.
Exactly. So these are all great points. And you just want to make sure, what do I need to be prepared? What is in the process? And what should I be looking for as an outcome here? So those are 3 things a lawyer can help work through with you. Hey, and there's 3 more things we want to hit. We want to hit, and they're all surround the courtroom and what happens when you get in the courtroom. So when up next, we're going to talk about 3 hearing situations where you want to meet with a lawyer ahead of time and the mechanics of how to do frequent meetings with lawyers that are very, very productive. Welcome, everyone. I'm Lee Meriwether, and with me is Todd Orston. Todd and I are partners at the law firm of Meriwether and Tharp, and you're listening to Meriwether and Tharp Radio on the new Talk 106.7. If you want to read more about us, you can always check us out online at AtlantaDivorceTeam.com. Well, today we've been talking about options for people that can't afford to hire a full-time lawyer and at what points, what would that look like? What's that called? There's several names for it. You use a consultation basis, an a la carte basis, divorce coaching, unbundled legal services. So those are all kinds of options to search on the web. But there are lawyers out there in every state, most states I know of, I don't know every state, who can help people through the process without actually representing them full time. And so we were talking about specific, like what would that look like in specific circumstances? But there was 3 that we hadn't gotten to yet. And I want to touch on them. We see them in most cases and most, every state's a little bit different. So, you want to talk to a lawyer about the process. And at what point can you request a hearing on a motion? So that's one of them. Temporary hearings and final hearings. And let's dive into that a little bit, but I want to leave some room at the end for talk about the mechanics and some really practical tips on how to communicate with a lawyer, maybe long distance.
Well, I'm gonna hit it from a general point of view, which is whether you are talking about motions hearings, temporary hearings, or final trial, that's where the proverbial rubber meets the road, right? That's where you have not been able to reach an agreement. The issue or issues that are still yet to be decided or agreed upon, you now have to present that issue to the court. Temporary hearing is that you're at usually towards the beginning of a case, sometimes the middle, and you need something to be put in place by the court to get you through the entire process.
Right, because a lot of times these divorces can take a year or two.
Right. Who's going to pay the mortgage while the divorce is pending? Who's going to
live in the house?
Who's going to live in the house? Who's going to drive which car? Those might be temporary issues. Motions hearings, that a motion might be filed that basically, they're all different types of motions, and we'll go into a few of them, but basically where you are looking to the court and you are saying, hey, we filed a motion and we need some help on this one particular issue. It's a legal issue or a factual issue, but it's a legal issue that we need the court to rule upon, and that's going to help us either get to an agreement or at least get us through to a trial. Those, and then, of course, a final trial, you need to spend some time with an attorney. That is, if you said to me, Todd, I can really only do one consult. That's all I can afford. Then you wait until you have one of those three things coming up. And if I had to prioritize, I would say if you really know you have enough money for a consult.
Mediation in there.
You know what? Except for the fact that if you said to me, Todd, I will have enough money for one consult.
Ooh, that's tough.
I know.
Because you do the mediation and they settle the case.
Yeah, but if you don't, then you don't have the help to prepare you for a final trial.
My answer would be save up some more money for at least two.
Well, I get that, but that wasn't the hypo.
I'm changing it.
My advice would be win a lottery. Come on. So if you have enough for one, I would say the final trial. You have enough for two would be mediation and trial. But really, that's these hearings. That's where the rubber.
Add temporary hearing to that. Those are probably the priorities.
Probably
final temporary, final mediation and temporary.
Because you can get by at in filing a divorce action, you can go online and get enough information to file a petition. Because especially in Georgia, it can be very basic. There are other states where it's a notice pleading state where you have to be very specific. There are states where you have to put everything you're really asking for. Property division, custody, everything. You have to be very specific.
Yep.
At that point, if you're in one of those states, absolutely you need to talk to the attorney, because if you don't put what you want into the petition, you may have waived your right to make a claim for whatever that is.
Exactly.
So here, it could be very general. Equally or equitably, rather, divide the assets. Custody needs to be dealt with. Yes, this is what I want, but it just needs to be pursuant to what is in the best interests of the children, and you can keep it very general.
So let's talk about why the final hearing is the most crucial part if you can't settle along the way. Because you're going to need help when you go to that final hearing. I'm just going to hit just a few high points because we only have a few minutes left. So one is just help with your what's called direct examination, where you may be giving your side of the story or asking your witnesses on the stand. Cross-examination. What can you ask your spouse from the stand, and how to prepare for that? How to get witnesses to court, how to subpoena witnesses. A lawyer can help explain that to you. Preparing your final judgment. So one of the most, what's very helpful in communicating with the court is telling the court, Judge, at the end of the evidence, here's what I would like you to do. And then preparing a proposed final judgment, a proposed parenting plan, proposed child support payment. Those things will help you explain your case to the judge. So it's very powerful to walk into court with those things prepared, and a lawyer can help you with that. So getting those things in, and I will say also, if you have more than just one consultation, plan on having multiple consultations around a final hearing, because from a standpoint of lawyers, that's the single most expensive event in the whole divorce.
Yeah, absolutely. And on top of that, you're not going to, from a single 1 to 1.5, maybe even 2 hour consult, you're not going to be able to fully prepare yourself.
Depending on the complexity of the case.
Absolutely. If it's a very non-complex case, absolutely, I agree with you. But if there are some complexities, if you're dealing with custody and parenting time and child support and alimony and division of property, basically what we call the 4 core areas of divorce, then one single meeting may not be, or probably will not be enough. You may want to have a meeting with the attorney to just wrap your arms around, okay, what's the trial going to look like? What are the issues? What does it mean when I cross-examine, direct examine a witness? What are leading questions? What are direct questions? All those types of things. What's hearsay?
Yeah.
Okay, that comes up a lot when we watch pro se litigants trying to do it on their, and Bobby's dog's uncle said you can't go into what they said. It's if they're not here, then it's hearsay.
And a good point about that is because sometimes people think they can say that in the courtroom and they think it's going to make their case.
Yeah.
And then as soon as they realize, I can't say that, no, maybe I need to settle.
But on top of that, they've prepared their entire case based on, I can bring up what Bobby said, and I can bring up what my uncle said, and I can bring up what, but they go in and they're shut down, and they're sitting there and they don't know what to do.
And they have no case.
Yeah.
So those things are critical for meeting with a lawyer. All right, well, let's talk about mechanics just for a second, because there are situations where you may live in one state, but you have to, you have a lawyer and you have your case in another state. We've seen situations where what you do is, we're going to get a little technical here. You set up like a Zoom. It could be a telephone conference, but you create a Google document, and you can actually share that link. If you want to learn how, you can just Google this or in YouTube. I'm sure there's a video out there for it. But what you do is you send the lawyer the link to your Google Doc. And so the lawyer opens it up, and the lawyer is actually looking at the same screen you are. And so as you're talking with the lawyer says, all right, here's how you want to present your case. You probably want to reference this case or this statute. And so you're typing it out as the lawyer's communicating it with you, because sometimes lawyers, they can say, here are the talking points you want to stick with in this hearing. Don't go beyond it because you're just going to make the judge mad. But no, don't go beyond it. So, and you write out these things. So before you get off the phone with the lawyer, you say, okay, Mr.
Here are my notes.
What
you've seen me write them.
You see, am I missing anything? You know what? I would change that intro paragraph to say X, Y, and Z. And that is so powerful because the lawyer can change it on the fly. The lawyer can actually get access to the Google Doc and make the changes him or herself.
That's right.
So it may sound simple, but it's a tool that a lot of people don't know about. And you can do that. Now, you can do there's these software out there, like it's Zoom, I think is what it's called. I think if you go to zoom.us, you can set up a face-to-face through a webcam meeting with a lawyer. So you can get, let's say your case is in Alabama and you live in Georgia, but you're limited funds. You can't drive out there and you need help during preparing. Some lawyers, especially if you prepay, they will have meetings with you by Zoom or telephone conferences. And so you can get a lot of information that way, because if your case is in Georgia, unless your lawyer I may say your case is in Alabama, unless your lawyer here in Georgia is also licensed in Alabama, they can't give legal advice. So
the bottom line is there are options, just like there are options to whether or not you retain, or if you can't afford, there are options and you can just have consultations on bundled services. There are options. Your attorney, the attorney that you're going to talk with, may not understand Zoom, may not understand how to do what you're talking about. Educate yourself.
Yeah.
Go online. Look at the company, the Zoom, whatever tool it is. Figure out how to use it, and then when you call, you say, "I'd like to use this tool."
Hey, you know what? Unfortunately, we are just about
unacceptable.
Out of time.
Unacceptable.
I did want to tease this. We are at Meriwether and Tharp working on an online divorce coach system that we hope to launch at the end of the year to help all this group of people that we can't always help because of all kinds of financial reasons or just limitations in time. Hey, everyone. We hope to get that out soon, and thanks so much for listening.
This audio program does not establish an attorney-client relationship with Meriwether and Tharp.